Hello and welcome to this third video on negligence. This video is revising causation, defences and damages. So in the overall structure, A, B, C, D, D, we can see that video 1 dealt with the duty of care, video 2 dealt with breach, and now we're looking at the remaining elements. We're also going to be referring to a scenario question from the AQA A Level law paper of 2022, and we looked at this in the first video and identified the negligent act was driving whilst distracted by a mobile phone, and the damage caused was that Jake suffered a broken leg. So first of all, we're going to have a look at causation, and remember that another word for causation is damage with no S. Damages with an S is compensation. And what we're looking at is the chain of causation, that the breach caused the damage. And as I've said, you don't want to confuse that with damages. And as with criminal law, there is factual and legal causation, but note that whilst the but-for test applies, the test for legal causation is different, and so are the cases, and you should try to use the right cases and not get confused. You shouldn't be saying something is a significant contribution, as that is the test in criminal law. So for factual causation, you're going to use the but-for test. I'm going to look at that in a moment. And for legal causation, you're going to use the remoteness test. And an example of remoteness is it's like cutting off the compensation at a certain point. It's when it is too far away from the original negligent act to actually be compensated anymore. So if, for example, someone reversed into my car and my car then had to go to the garage and I had to have a hire car, and then on my way to an interview for a job as a part-time judge, I had the car broke down and I couldn't get there, and then that meant that I could never become a Supreme Court judge like Lady Hale. At some point there is going to be a point where the damage caused to me is too remote from the original negligent act of reversing into me. So whilst the test for factual causation might be proved, the claim would fail on the test for legal causation. So let's have a look at factual causation. It uses the but-for test if it were not for. So it already has a negative in it. So you must remember not to have a double negative. So the claimant has to show, but for the defendant's actions, the claimant would not have suffered the harm. And in Barnett and Chelsea, the claimant couldn't show that because whilst there was a duty and a breach, even if the doctor had come, then her husband would still have died, as he would have died from arsenic poisoning. So in that case, there was a duty owed by the doctor to the patient, and he breached that duty by failing to reach the standard of a reasonable doctor, but wasn't an actual cause in fact of what happened, because he would have died anyway from arsenic poisoning, whatever had happened. So if we apply factual causation to the scenario, we can say there is factual causation, as but for Candy driving whilst distracted by her phone, she would not have collided with Jake's bike and Jake would not have broken his leg. So there are a couple of things to note there. First, that you need to identify the negligent act, which was being distracted by her phone, and that you need to get to the end result. Many students stop at colliding with Jake's bike, but that's not the end result. We need to get to the fact that he broke his leg. But factual causation, as we've just seen from the example, is not the end of the story. You then have to consider legal causation. And legal causation asks if the type of harm was reasonably foreseeable. If the type of harm is not reasonably foreseeable, it's too remote and you cannot claim. And this is sometimes called the remoteness test. So in the leading case of the wagon mound, the defendant negligently allowed oil to spill into Sydney Harbour. The oil spread to where some welders were working, and a spark landed on the water and the oil caught fire, causing damage to the claimant's wharf. The welders had been told by experts that the oil would not set on fire. So in the case, they had to identify what type of harm was reasonably foreseeable from an oil spill. And they said that damage by the actual oil was reasonably foreseeable, but fire damage was not a type of harm that was reasonably foreseeable. So they could claim for damage caused by the oil, but not by the fire. Once it's established that the type of harm is reasonably foreseeable, it doesn't matter that the harm occurred in an unforeseeable way. The defendant will still be liable. And this is Hughes v Lord Advocate. And in Hughes and Lord Advocate, it was foreseeable that the type of injury, a burn, would occur when leaving a gas lantern by a hole. The fact that it was caused in a way that was not foreseeable, an explosion, because there'd been a build-up of gases inside the hole, didn't matter. There would still be liability. And this is also the case for if someone suffers harm to an unforeseeable extent. Once you've established the type of harm is reasonably foreseeable, it doesn't matter that the harm occurs to an unforeseeable extent, the defendant will still be liable. And in Bradford and Robinson Rentals, the court said it was foreseeable that the claimant would suffer an injury related to the cold when he had to drive for a long way in a car with no heating. And once that type of injury was foreseeable, the defendant was liable for frostbite, as although it was unusual, it is an extreme form of injury from the cold, and so there was liability. In paper 2, there are not so many events that break the chain. It's not as common as in paper 1 at all in paper 2. So just remember, only unforeseeable acts will break the chain of causation, which is the firework case of Scott and Shepherd, when the actions of the stall holders who threw the lit firework from person to person were foreseeable, and this meant the defendant was still liable for the injuries suffered by the claimant, who was blinded in one eye when the firework that had initially been thrown by the defendant exploded. So this would apply if, for example, someone is injured and gets bad medical treatment, because that is unfortunately foreseeable. So the act of a doctor who makes an injury worse would not usually break a chain. And the last thing you need to consider, as with criminal law, is the thin skull or eggshell skull rule. And this says that once the type of injury is reasonably foreseeable, the defendant must take the claimant as he finds him and is still liable where the claimant has an unusual characteristic that makes the damage suffered worse. And in tort law, this comes from Smith and Leach Brain, where the claimant's husband was struck on the lip by some molten metal and it triggered cancer, which he later died of. And the defendant was responsible for the death, as the burn was a reasonably foreseeable type of injury, and the defendant had to take the claimant as they found them. So if we think about our scenario, here the type of loss, always say the type and identify it in a scenario. Here, broken bones or personal injury is reasonably foreseeable if someone drives whilst distracted by their mobile phone. So the loss is not too remote and can be claimed, and the Wagon Mound is the legal authority for legal causation. If any of the other things applied, you'd mention them. If they don't apply, you don't need to, and they don't here. But if they did, you would say it does. Once the type of harm is reasonably foreseeable, it doesn't matter if the damage occurred in an unforeseeable way, to an unforeseeable extent, or as a result of a pre-existing condition, which is the thin skull rule we've just talked about. So moving on to defences, there are only 2 defences in tort law, which makes it a bit easier. Contributory negligence is a partial defence, and consent or volenti non fit injuria is a complete defence. Let's look at contributory negligence first. It was put into statute in 1945 in the Law Reform Contributory Negligence Act, and this allows the claimant's damages to be reduced according to the claimant's responsibility for their loss. So it's reduced by a certain percentage according to how much they are at fault. So you could either be partly responsible for an accident, for example, by stepping out into the road whilst you were distracted, or by what you do, you make the harm suffered worse. So if you were in a bike, you didn't have your bike helmet on, or if you were in a car, you didn't have your seatbelt on, for example. In Sayer and Harlow, the claimant got trapped in a public toilet and she tried to climb out of a window and she fell off the toilet roll holder and injured herself. So she actually contributed to the accident, and the court reduced her damages by a quarter, by 25%, to reflect how much she was at fault. In Froome and Butcher, the court said that they would reduce a claimant's damages by 25% if the accident wouldn't have happened at all if the claimant had been wearing a seatbelt, but by 15% if not wearing a seatbelt made the injuries worse. So the court are going to consider whether the claimant's actions were reasonable in the circumstances. So any action that a claimant takes that is reasonable in the agony of the moment, in the heat of the moment, or because they're acting in an emergency maybe, and in results in more damage will not amount to contributory negligence. And that comes from Jones and Boyce, an old case where the claimant jumped from a horse-drawn coach and broke his leg when he thought the coach was about to overturn. It did eventually stop safely, but he was allowed to claim full damages because he was acting in an emergency in the heat of the moment when he jumped, and so he didn't have his damages reduced. The other thing to think about is children. There is no exact age at which a child can be held to be contributory negligent. And we have got the case of Morales and Ecclestone, where an 11-year-old boy was held to be 75% responsible for his injuries after running straight out into the road. So if you have a child in a scenario, you can speculate as to whether they might be old enough to be held to be contributory negligent. The other defence is consent. And here you have to show that the defendant knows of the risk of injury, which is a subjective test, and that they voluntarily accept that risk. So accepting the risk of injury was shown in Morris and Murray, where the claimant was a passenger in an aircraft that crashed after both the pilot and the claimant had been drinking heavily. And the claimant got into the aeroplane knowing that the defendant was seriously intoxicated. The defendant was killed and the claimant was seriously injured, and it was held that the claimant had consented and accepted the risk of injury there and had no right to compensation. So as it's a full defence, you need to be careful to say the effect of it, which is that there will be no compensation awarded, unlike contributory negligence, which is just a reduction in the amount awarded. You have to voluntarily accept the risk of injury, so the consent must be given freely. And that wasn't the case in Smith and Baker, where the employee had no choice other than to continue working under a crane as he needed the job. So in this scenario, you've been specifically asked to consider contributory negligence. You may not be in a longer scenario. You may have to decide whether you need to include it. So here, Candy, remember it's Candy here because she is the defendant and she is going to say, well, I've got this defence. Candy may try and rely upon the partial defence of contributory negligence. She could argue Jake did not act reasonably and contributed to his loss as he had forgotten to attach his lights and he was cycling in poor conditions. So in that case, she could even say that he had contributed to the accident actually happening. So his damages may be reduced by a percentage to reflect his level of fault under the Law Reform Contributory Negligence Act 1945. Like the case of Sarah and Harlow, the claimant's compensation was reduced by 25% for trying to climb out of a locked toilet by standing on the loo roll holder. So here, Jake's damages are likely to be reduced by a certain percentage. So we're going to move on and have a look at damages. So many of the scenario question will ask you about the rights and remedies of a party, and damages is one of the main remedies in tort, with the other one being an injunction. For negligence, you are primarily looking at damages. The aim of damages is to compensate the claimant, to put them back in the position they would have been in had the accident not occurred, as far as money can do, with the last part of that obviously meaning that if you have been killed or seriously injured and had to have limbs amputated, for example, you will not be able to be put back in the position you would have been in. Often you won't have very much time in the exam to deal with damages, so you just need to try and say as much as you can. Maybe just stating the aim of damages if you can, if you've got time. And this links to causation because losses that are too remote can't be claimed for. So they are not going to be payable to a claimant. Claimants are under a duty to mitigate. This means minimise their loss. So they have to take reasonable steps to minimise their loss. So if they've got a leak coming through the ceiling, they can't pile up all their possessions underneath it and say, oh, look, it's damaged all this. They should be moving things out of the way. And another example is claiming the cost of hiring a Ferrari whilst your Mini is being fixed. This is a picture of the board that I wrote out for damages, and it shows you there that it just says the aim of damages, and then it shows you how to calculate damages. So special damages are able to be calculated specifically. That's how I try and remember it. And they go from the date of the accident to the date of the trial. And then after the date of the trial, we are being a bit more speculative, and we're trying to estimate into the future what the damages are going to be. And these are called general damages. Some of them are easier to calculate, and they are pecuniary or monetary loss, and some of them are non-pecuniary. So special damages include damage to property, loss of earnings up to the date of the trial, and any medical costs up to the date of the trial. And then pecuniary general damages after would include loss of future earnings and the cost of future medical care. Non-pecuniary general damages, you can always mention the injury itself, pain and suffering, and loss of amenity, which means you're not able to do something that you previously enjoyed. So if you have gone blind, you can no longer read. If you've lost a leg, you can no longer play football, for example. All of those things you can use the Judicial College guidelines to help you calculate them. So the structure of awards is that the court can only award a lump sum, and that's usually the appropriate way to proceed for damage to property or relatively minor personal injury. And interest is payable on this. That comes from the case of Jefford and G. Since the Damages Act 96, it has been possible to have a structured settlement, but this needs to be agreed by the parties, and if it's for a child, it would have to be approved by the court, but can't be ordered by them. And this allows for periodical, often monthly payments, and is appropriate where the claimant is a child or where there is a long-term, very serious injury, such as brain damage, or a very large amount of compensation has to be paid and the claimant's future is unclear. If a child is awarded compensation, the award will be dealt with by their parent or guardian. So applying that to the scenario here, Jake's remedy is damages for personal injury, his broken leg. The aim of damages is to put Jake back in the position he would have been had the accident not occurred. He's under a duty to mitigate. Special damages can be calculated specifically and are up to the date of the trial. General damages apply after the date of the trial, and they're split into pecuniary and non-pecuniary. In relation to general non-pecuniary losses, he would be awarded compensation for the injury itself, pain and suffering, and any loss of amenity, for example, not being able to play football. So I just want to finish by saying the best way to improve is to practice your negligence questions. Negligence is the foundation of everything in paper 2, so it's very important, and is asked in a variety of ways from multiple choice right up to being part of a 30-mark scenario. Use the past papers and write questions out and then check them using revision booklets and suggested answers. The identify, state, apply, conclude structure is what I would recommend. This is a menu to pick from, so you may have questions that zoom in on a particular issue like causation or damages, or you may have to do the whole of negligence. And it is important to practice under time conditions to make sure that you can write everything that you need in the time available. So I hope that's been useful. Thank you.